the Metcalf Circuit Court docket. I'll have to pause periodically. People keep trying to get in. So, all right, there we go. All right, we're going to take our civil matters up first. And to begin with, we have 21 CI 003 Commonwealth Transportation Cabinet versus Neal.
Yes, Your Honor. I'm Ann Meyer again, representing the Transportation Cabinet.
All right.
And this is a motion for a default judgment and a permanent injunction against Mr. Neal. He has not responded, and I don't know if he's present this morning on Zoom. I believe you all sent him a link, or the clerk sent a link to him.
Yes, ma'am. I don't see anybody identified as Mr. Neal, but I will ask just to be on the safe side. Is Mr. Neal on this teleconference?
This is Russell County Detention Center.
Okay, well, I do have a couple of employees from the Transportation Cabinet listening in case you're, there's any additional proof that you would like, Your Honor. So,
okay.
Motion.
Yeah, and I don't expect that there is. I've read your motion. After getting that, I went back and read the complaint. You're not asking, this is not the kind of case where one would be trying to seek monetary damages and have to put on any proof about monetary damages. This is essentially asking for someone to, for lack of a better way to put it, I suppose, respect the rules regarding rights of way around the highways and not block the rights of ways when you don't have the right to leave your things there, is basically what
yes,
what it is. Yeah.
And there is a second component to it. We're all requesting that he either apply for a permit and properly screen the recycling yard located on his private property or remove the vehicle. So we have two issues. Number one is the parking on the right of way of Kentucky 869, and also a permanent injunction requiring him to either apply for a permit and properly screen or remove the vehicles on his private property.
Okay. And again, I don't see anything wrong with that. I've looked at your tendered. I've looked at your tendered judgment, and it covers both of those aspects. So unless you have any sort of issue with that tendered judgment, I believe that's ready to be entered.
All right, Your Honor, that's all that we have. So thank you, and we appreciate it.
Let me ask you to bear with me for a minute, because I just noticed that my deputy clerk got disconnected and is trying to get back in the meeting, which means that none of this was getting recorded. So I'm probably going to need to get her back on here and get the recording started, and then at least recite all that back on the record.
Certainly, Your Honor. But
she doesn't have a microphone, so she can't talk to me, but I just saw that her little rectangle disappeared. And all right, now we're back. I have a recording button going up here. So I'm going to put this back on the record. 21 CI 003. This is the Transportation Cabinet versus Neal. Mr. Neal has been is the subject of a complaint that was filed by the Transportation Cabinet. He's been duly served. There's proof of that in the record back on January the 12th. No responsive pleading is in the record. The motion for default judgment was also served on him via mail. This court entered a notice setting this Zoom hearing, this teleconference, sent a copy of the link to him. He is not on the link. The Commonwealth, the Transportation Cabinet, is requesting a permanent injunction regarding removal of encroachments on the right of way, and also requiring or seeking that he be ordered to either provide the appropriate screening and obtain a permit to allow him to do what he's doing or to be prevented from doing that going forward. And I do not believe that those are controversial assertions. Those are in the proposed judgment, and I plan on entering the judgment as tendered.
Thank you, Your Honor.
Okay, thank you.
Okay, may I have permission to leave the court?
Oh, sure. Yes, ma'am. Thank you. All
Okay.
right. That's e-filed, so we'll just get to it in a minute. My next civil matter is 13 CI 100 South Central versus Skaggs.
A motion, Your Honor. The order that was entered in that case many years ago, March of 2014, it stated that the master commissioner was to sell real estate, including the 2001 Fleetwood mobile home, and gave the VIN. That mobile home was never signed over to the purchaser. The problem wasn't discovered until the purchaser at that sale tried to do a new sale. We're just asking that the master commissioner be ordered to sign the title over to the purchasers.
Yes, sir. I don't see any problem with that. I've looked at your motion, also your tendered order, and it's fairly, I mean, the folks that would have been the defendants in this case were the subject of this foreclosure, some 7, 8 years ago. And so that's kind of a done deal. And therefore, I believe that your request is well taken. I think you electronically tendered that order. So when I get finished here, I can get on and read it, or I'm sorry, electronically sign it and get it entered. Okay.
Okay. Thank you, Your Honor.
All right. Thank you. Oh, I'm sorry. All this goes together. That appears to be it for the civil docket. We're going to move into our criminal cases at this time. Anybody have a preference for what's going to get called? I've got a great big stack here, and I'm
Judge,
lost where to start.
I don't know if John or Risa, if y'all have any hearings. I've got one with John Martin, and Julie was my only witness. I don't know if she's got any other cases on.
You can go ahead with that, Mike.
Okay.
All right, we can do that. This is 20 CR 27 Commonwealth versus Martin. Thank you. All right, Mr. Richardson, are you ready?
I'm ready, Judge.
All right, and is Mr. Austin, are you doing this one? All right, you're on mute for future reference, okay?
Yes, Your Honor.
All right, fair enough. Ms. Atkins, can you raise your right hand, please? Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
Do.
All right, proceed, please.
All right. You state your name for the record,
Julie Atkins.
and you operate the U-Turn office.
I do.
And were you monitoring John Martin for bond conditions?
Yes, sir, we have been.
Okay. And did you send a report to the court into our office dated January the 24th about some violations?
I did, yes.
Okay. Can you tell the court what the violations were?
On 119, we attempted to call Mr. Martin in for a random screen. At his cell number, there was a continuous ring and no opportunity to leave a voicemail for a message. We also have his father's number on file, but his father asked us to not call that number anymore. That basically, well, I think he actually said he was tired of fooling with it. Then again, on the 21st of January, we called Mr. Martin's cell number with the same result. Just continuous ring, no opportunity to leave a message for a drug screen. So we have, if he's not answering his phone, we don't have any way to get him in here for drug testing.
I can explain.
Hold on, Mr. Martin, you'll get your turn, okay?
Okay.
That's all the questions I had, Judge.
All right, Mr. Austin, do you wish to ask any questions on cross?
No, Your Honor, I have no questions for Ms. Atkins.
Mr. Richardson, do you have any additional proof?
No, Judge, is my only witness.
All right, Mr. Austin, do you have proof?
I spoke with my client yesterday and he informed me that he had some medical issues, including I think a surgery on his hand due to a construction accident. And he had also had his phone stolen. But I believe that is what he was going to express to y'all just a few minutes ago. He knows more about that himself and has been advised not to address the actual court case, but the circumstances surrounding his inability to contact Miss Atkins.
Well, I mean, if you want me to consider that, you can put him on. I'll have to swear him in and he'll have to testify under oath, but that's
Yeah.
your and his decision, not mine.
I mean, I feel that is what he wants to do. I told him yesterday that it probably wasn't the best idea, but he
Okay, so Mr. Martin, your attorney is giving you his advice here on the record that he does not think it would be beneficial for you to testify in this hearing. However, you're the defendant and that is your decision to make. So do you wish to testify or not?
If it will help me, yes.
Well, are you listening to what we're saying?
I'm trying to, yes.
Is the problem that you cannot hear me?
No,
Or
I
is,
can.
all right, so your attorney just said he did not think it would be beneficial for you to testify. So that's the advice that you're getting from your attorney.
Okay.
that also
I'm not going to give you any advice because that's not appropriate. So,
Right.
that is also the only way to get the information that you were telling me about on the record. I can't just tell him what you told me. It doesn't actually
Right.
count. So if you want to tell him about all the stuff you told me yesterday, then you'd have to testify.
Okay.
so let me
Yes, I'll testify.
raise your right hand, please. Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Okay, Mr. Austin, you may ask.
Could you please testify about the events that led to your inability to get a hold of Miss Atkins?
Yes, I had to go to Louisville for emergency surgery. They actually had to cut a hole completely out of my hand. I mean, you can see plumb through my hand. I mean, it was an infection. I had to stay up there. I forget how long. My phone got stolen, and I completely forgot. My number got changed when I got a new phone. I completely forgot, and I'm sorry. My father has reconsidered on being able to call him. You can call him anytime. But I really appreciate. I really like to get out.
Is that it?
I'm sorry. I mean, but they did cut a hole completely through my hand in Louisville.
When did you have the surgery on your hand?
It was earlier this year or last. I can't exactly remember the dates.
You don't remember whether you had the surgery at some point in the last month and a half, which would have been this year, or
it was
longer ago than that, which would have been last year?
It was last year, sir.
All right. Mr. Austin, anything else?
I have no further questions, Your Honor.
All right, Mr. Richardson, do you have any questions?
I just got a few, Judge. Mr. Martin, you know that you've had to test with Miss Atkins for quite a while now, correct?
Yes, sir.
Okay, so after you lost your phone, did you make any attempt to call Miss Atkins with to let her know what your new number was?
I forgot that I got a new number. I don't know much about technology. Someone else set the phone up for me, bought it for me. I mean, I'm not very good with technology. I didn't know. I done forgot that I got a new number, everything. I just didn't realize my stupidity.
I don't have any questions or any more questions.
All right, Mr. Austin, any additional proof?
When you say you forgot that you had a new number, are you saying that
I didn't realize that I had a new
you didn't realize that the number changed when you got a new phone?
I didn't realize I had a new number, yes. I mean, I didn't set the phone up or anything. I had someone else get it for me. I was in the hospital.
No further questions.
All right, Mr. Richardson, anything?
I don't have anything else, Judge.
All right, Mr. Austin, do you want, wish to make an argument here?
I would ask that he be put back on U-turn supervision or anything else the court would deem necessary, or at the very least, give him a sanction rather than revoke his bond completely.
All right, Mr. Richardson.
Judge, he's clearly violated his bond conditions. You know, I'm not buying what Mr. Martin's saying. He knew his number changed and he didn't make any effort whatsoever to let Ms. Atkins know what the number was, probably because he didn't want to get calls from her. He's been sanctioned before. It's part of the record, even down in district court. And this is a trafficking case. So this is not a possession addict case, you know, and so I think that he's violated his bond conditions. We're going to ask that it get revoked.
Well, listen, this is, by my count, the fourth time that there's been a bond violation. I mean, you look through going back to the district court, and this has happened over and over again. You know, regardless of why you didn't have your phone number or whatever, when you're under an obligation to make yourself available for testing, that's your responsibility to make yourself available for testing, not anybody else's. And you didn't do that. I don't think that the surgery had much to do with it because it happened well before these issues that Ms. Atkins has testified about. I mean, I'm not minimizing that. I'm sure that that was a traumatic situation, and I understand that. But you know, you've been at this for a year now. You know, you should know that you're supposed to keep her in the loop. I mean, we've already had to do this once in this case, and twice in the district court case. So, you know, from the standpoint of the Commonwealth's motion, at this stage of the game, I'm granting that motion. We're going to set this for a pretrial conference on March the 9th. And, you know, conceivably your attorney can speak with you between now and then. And, you know, we'll talk about whatever there is to talk about when we come back on March the 9th. Okay? All right. Thank you.
Your Honor, as far as private counsel, Mr. Kimball's on and also Johnny's on as well. I think Johnny's got 2 cases and Mr. Kimball's got a sentencing.
All right. Mr. Kimball's just got the one, so let's take him so that he can go on about his business.
I see Bruce Brown down there too. I didn't.
He's on for I think he had tried to add Kerry Compton. I was told
Yeah,
about that this morning.
he's got an arraignment.
Can we see if my client, who's Robert Vincent, was able to get on? He was trying to get on the site. I think he was going to call in, but can we see if he's on the line with us at this point?
All right, Robert Vincent.
He was trying to get on the site, and I told him if he couldn't do that, to call the number that was listed on the notice as well.
Yeah, doesn't seem like he's answering. I don't know. I've got a phone on here. It's 502-550-4363, but I'm not sure.
Yes, that's Timothy Mann with Weber Olsey's on one of the civil matters, Your Honor.
Let me.
Oh, which civil matter are you with? Because I've already done all the civil cases.
It was Jefferson Capital versus Samantha Phillips. I'm sorry, Your Honor.
Oh, somebody contacted my clerk in Metcalfe County and said they were renoticing those.
Okay, very good, Your Honor. Thank you.
All right, thank you. All right, Mr. Kimball, I may have, I got distracted. What did he say?
Let me see if I can just give you a number, maybe, call them, 270
I don't know how to do.
670 6100. And if we can't get him on the site, we can get him on by phone.
I don't know if you want to try to call him. Do you know that he's had the chance to look at this pre-sentence investigation report?
Your Honor, I don't think there's really anything in dispute. This, we've agreed, home incarceration. So I don't think there's anything really that we have in dispute.
Okay.
Have you tried to call into the Zoom link this morning? You can't get it to go through. Hold on just a moment for me. He said he can't call in. How do I put him on speaker?
Mr. Vincent, did you call the number? Because I've already had two other people that called the number and participated by phone. What kind of phone are you calling with? Yeah. So you tried the phone number. I'm not talking about the video link. I'm talking about just the phone number that it gave you. Okay. All right. Well, I'm going to put you on speakerphone and we're going to try to do what we do. Mr. Kimball's here and he said he would agree to proceed with you on speakerphone. So if you'll bear with me, I'll do that. I don't really have it set up for this to work real easy. So I'm trying to make it work. Okay. All right. All right. Can you hear me?
Yes.
Judge, he was coming through on our end, so just to let you know that.
All right. Mr. Vincent? Lost him. We're going to have to call him again. Hope my vehicle doesn't ever break down wherever he is.
Mr. Vincent? Okay, hold just a moment.
All right, we lost you somehow. Let me get you back on here, okay? All right. All right, you still with us?
Yeah.
All right. Mr. Vincent, what we're on here for is a final sentencing in this case that you have in Metcalf Circuit Court, 19 CR 076. There's already been an agreement entered in that case, and just for the purposes of proceeding with the sentencing, this is the next logical step here. Okay. Are you satisfied with proceeding over the phone?
Yes.
All right. Mr. Kimball is on. He is also satisfied with proceeding over the phone. I don't believe the Commonwealth has expressed any objection either. Mr. Kimball, is there anything that you, on Mr. Vincent's behalf, need to say prior to imposing sentence?
There is one thing, Your Honor. I personally yesterday came to Bowling Green. We sat down and talked. And of course, the agreement that we have reached with Commonwealth, which I think was done September 10th, has been pending for a while. Had a variety of interruptions that caused me today. The thing that I found out from him yesterday, though, in my meeting with him, was that he now has stage 2 liver cancer. So we've entered all these agreements prior to what I found out yesterday. I feel compelled to report that he's under treatment. Doctors here in Bowling Green for that. But I'd like the opportunity to at least get some full statement regarding that, possibly a letter or something that I could share with the court, because that's certainly a big change in someone's life they think they're going to go through and do their home incarceration and be done. That does not sound like a good diagnosis.
Understand. So are you proposing that that diagnosis would, is what you're going to be doing is asking to relieve him of that home incarceration part because of his medical condition, or what impact are you suggesting that would have on what we're doing?
I think if that was verified, or that we might all agree that that was appropriate to do. Realize I don't have any proof of what he's told me about it, but I think I would be prepared to go forward with it today, enter the agreement that we have, and then if I document that through a statement from his doctor, then I may well want to get back with the Commonwealth and the court on that, though.
Your Honor, here's what I propose. I propose that we go ahead with the agreement today, put off for 2 weeks for him reporting to Julie to set up that home incarceration. Mr. Kimball, in the meantime, can give me the documentation, and if we enter an agreed order between that time, obviously he wouldn't have to put the monitor on. But then, that would also give him time to notice a motion as well. We can't reach an agreement with the Commonwealth.
Yeah, I mean, I think that might be fair, Mr. Kimball. We could go ahead and sentence him today, and as Mr. Gardner's pointing out, I could just give him a date certain to get that ankle monitor on, put it out a couple weeks, 3 weeks, whatever it is. And that way you all could talk in between now and then. And if he doesn't hear anything and doesn't get any approval from you, then he would need to get the ankle monitor on at the point in time that we decide. But if he does hear from you that that's not going to need to happen, then he will know. Okay.
Perfect,
All right.
Judge.
Mr. Vincent, do you understand that?
Yes, yes, sir. Dave.
All right. I know I'm probably yelling in your ear because I'm trying to talk. I'm talking louder so that those guys can hear me, and you're right beside me. All right. All right. So other than that issue, is there anything else that you all want to talk about before I impose the sentence? Is that everything?
That's fine. Yes, Your Honor, I'm fine.
All right. Mr. Vincent,
Yes.
based upon the agreement that you reached with the Commonwealth, it continues to seem to me right now that the appropriate thing to do is to sentence you in accordance with that agreement, which is a 3-year sentence, a fine and court costs, probate that sentence after service of an alternative sentence of 120 days, 17 of which you have already served, and allow the balance of those alternative sentence days to be done on home incarceration. Your probation will be conditioned also unless this changes for the same reasons that home incarceration deal might change. Your probation would have a requirement that you enter and complete an anger management course. The appropriate thing, like we discussed, for me is to order you to have your ankle monitor put on by, why don't we call it March the 10th, which is 2 weeks from tomorrow. And so, Mr. Vincent, if you don't hear anything else, you need to make arrangements to get that ankle monitor on with the U-turn program over here, which you're familiar with, by March the 10th, okay?
Okay, do I need that? Will my lawyer contact me, or do I need that? If I don't hear nothing, just go ahead and do that.
Yeah, I'm sure you all will be talking between now and then, but if he doesn't tell you that there's been an agreement reached and a court order relieving you of that obligation, then you need to make arrangements to have that obligation taken care of, okay?
Okay.
All right. As far as your fine and court costs, I'm going to give you 12 months to pay your court costs. I'm going to suspend on your fine. I think I have to impose it, but I'm going to suspend $900 of it. So you'll only have a $100 of that fine. The rest of it will be probated on the same conditions that your service of your sentence is probated on. You also are going to be under an obligation to report to probation and parole. We have a probation officer on here right now, and she is going to tell you what she wants you, or I guess it'll be Officer Ford that's addressing us. Or will it be Jason?
It's me. I just wanted to make sure you still lived in Metcalf.
Mr. Vincent, you still live in Metcalfe County?
Yes, yes, sir.
He does.
Okay. Can he come to the office tomorrow in Glasgow?
Are you able to get to the office in Barron County in Glasgow tomorrow?
Yes.
All right. So is there any reason that you can't get there? Usually we have people report by 9 a.m. The following day. So is there any reason you can't get there by 9 a.m.?
That'd be fine with me.
Do you know where the office is?
Yes, I do.
All right, good deal. So you'll report to Officer Ford, F-O-R-D, or at least, you know, that's who the name you'll give him when you go there. All right?
All right.
All right. Do you have any questions?
No, I do not, sir.
All right, Mr. Kimball, is there any question on your end?
No, sir. I appreciate the court. Robert, call me later on today and then we can talk. But I think you heard what's going on. I'll explain it if you didn't.
Yeah, Mr. Vincent, he's asking if you'll give him a call this afternoon sometime.
Okay.
Okay?
I sure will.
All right. Good luck, sir.
All right.
Good deal.
Thank you, sir.
Thank you. All right, Mr. Kimball, has that got you?
It does. Thank you, Judge.
All right, thank you. Have a good day.
You too.
Hey,
All right.
Judge, I just realized that I also had Jonathan Mattingly on for a bond revocation, and Julie was my witness for that. He
Okay,
had another bearing case. That's why I forgot about it.
she's still here. All right. People, if we're not doing your hearing, I need you to put your phone or tablet or whatever you're doing on mute so that we don't hear all your extra stuff. All right. Jonathan Mattingly.
Yes, sir.
All right. Mr. Austin, are you ready?
Yes, Your Honor.
Okay. Ms. Adkins, you remain under oath from our previous hearing. Mr. Richardson, you may ask.
Okay. Can you state your name for the record?
Julie Adkins.
You work at the U-Turn office.
I do.
And were you monitoring a Jonathan Mattingly on his bond conditions?
I have been, yes.
Did you send a letter to the court and to the Commonwealth on dated January the 26th of 2021, noting some possible violations?
I did send that.
Okay. Can you tell the court what the violations were?
On February the 1st, Mr. Mattingly called this office and reported that he had just served a jail sanction for missed test, and he was back out of jail, and we continued testing. On February the 4th, we called Jonathan in for his first test since being released on that sanction. He tested positive for marijuana and methamphetamine use. So we filed the violation on February 6th.
And he's got, I don't know if this has been covered before, but he's had violations dating back to May 2020 up until August, correct?
He has.
Okay. That's all the questions I had, Judge.
Cross-examination, Mr. Austin.
You said he was released from a sanction on February 1st.
Robert, I'm not quite sure what date he was released. That was the date that he called our office after serving the sanction to update his information with us.
All right. And when your test that you do for THC, does that show both active and inactive THC, or just one or the other, or
The test that we used that day would have given us just a positive or negative result, because that was just a field test, an instant test. So it would have just given us positive or negative marijuana.
all right. No further questions, Your Honor.
Redirect.
I don't have anything else, Judge.
All right. Mr. Austin, are you intending to put any proof on?
I don't have any proof at this time, Your Honor.
All right. What's your argument?
I have no idea how long his sanction was or when he got out. As far as the marijuana goes, I suppose it could definitely have been inactive and maybe something from a much earlier use than, but I would say that's pretty mute with the meth being in the system, according to the field test.
Yeah,
But,
I don't think that you're making an unreasonable observation.
no.
Mr. Richardson?
It wasn't just marijuana. I heard testimony, there was also methamphetamine that he tested positive for.
Sure.
And that's in the report. But he's obviously violated his bond conditions, Judge. And I wanted to note that, he's facing a possession charge here, but he's also got, I filed this motion in his Barron County case as well, where he's facing assault charges. The victim in that case is his father. And I know he's obviously got some drug issues, and I think we can work these cases out. It's going to be a lot harder, though, if he's out on bond violating his conditions. And he's obviously got a drug issue. So I think he's violated his conditions, Judge, and I'd ask to have his bond revoked.
Well, yeah, Mr. Austin is acknowledging, I think, that his argument may apply for marijuana, but it isn't going to apply for methamphetamine. And in addition, there was a litany of missed tests prior to that, so there wouldn't be any way to compare anything because there weren't any tests being done. And Miss Adkins had sent a previous report in, which I didn't do a warrant on because I thought he was in residential treatment. And then when she sent the second report, it had his end date of residential treatment and he had been out, but I thought he was still in because that was one of the things that happened during the course of this was that he went to entered and completed, I think, a residential treatment. He just got out sooner than I thought he did. So long story short, the, certainly dirty tests and also not reporting for tests are going to be violations of bond conditions. Mr. Mattingly, I'm going to grant the Commonwealth's motion to revoke bond in your Barron County case and in your Metcalfe County case. I'm going to set a pretrial conference for 4 weeks from now, which is March the 9th. Mr. Austin, I as far as I know, the Barron County case, you're not handling. So if you can pass along to Mr. I believe it's Mr. Spears, but I'm not sure if you can pass along to him what we're doing here. I don't mind putting the pretrial on a different day in Barron County if he'll just let me know. But for now, because everybody consented to doing both of these today during the Metcalfe docket, I'll do the same thing with the pretrials. But I can set them on a different day if you all decide to ask me to do that. Okay.
All right. I missed the day you put it for.
March the 9th.
March 9th.
That's 4 weeks.
Judge, he has.
No, I'm sorry. I'm wrong about that. That's 2 weeks.
All right.
Judge, his pretrial for his Barron case is scheduled for 1 o'clock today. Is that just going to get moved to March the 9th? I mean, I don't think I haven't talked to Josh fully, about the case. So.
No, I think that our clerk put it in as a revocation.
Oh, okay.
And didn't remember that we were going to do it over here.
Okay.
So, or do it on this docket. So that's just there won't be a pretrial except for we'll do an order today that sets that, and we'll set them both on March the 9th, and then we'll go from there. Okay.
Yes, sir.
All right. All right.
Judge, we still have Bruce and Johnny on here.
All right. I think Mr. Brown's just got an arraignment to take care of. Is that right?
Yeah, well, she hasn't been arraigned yet, but there was a pending motion to revoke bond that I was going to try to address.
Well, sure. But I mean, I'm gonna need to arraign her too.
I've got her right. I can bring her in now.
Yeah, all right. I wish I'd have gotten to that before Julie left. Well, I would like for her to get on here and talk to this chick, since the reason that she has a motion to revoke bond is that she's not allegedly going to get tested. See what I'm saying? Make sure you're on camera, Jan. The topic. Thank you. All right, Mr. Brown, the first thing is Miss Compton actually has two cases.
Yes.
So I'm going to, obviously I can't just transmit this through the, but she's got two indictments right here. Are you asking that I read those indictments to her, or do you want to, can I just tell you what the charges are and you?
Yeah, we waive a formal reading.
Okay. In 20 CR 53, it's possession, first degree, first offense, drug paraphernalia, DUI first, and speeding 26 over, or 26 or more over. In 20 CR 64, it's possession, first degree, first offense, drug paraphernalia, resisting arrest, and DUI first offense. The offense dates are June 13th and March 3rd, respectively. So it looks like they're flipped around there in terms of occurrence dates. The first question I'm going to have for Ms. Compton is for you to give, tell me her address, because they've sent her some stuff and it's come back and she's got two different addresses on these two indictments. So I need to know what her address is for the record.
What is your address?
10571 Austin Tracy Road.
10571 Austin Tracy Road, Fountain Run, Kentucky.
All right. Well, that makes sense because both of these were Edmonton addresses, so that's a ways away from Fountain Run. All right, so you're waiving an explanation of rights and a reading of the indictment, correct?
Yes, Judge, and we plead not guilty.
All right, we're going to go ahead then and enter a plea of not guilty. I wanted to get Julie back on here because the basis of the motion from the Commonwealth is a report that we got from Julie that there was a no-show for testing in February, and that there had previously been a test that was positive for methamphetamine prior to that, I believe. And this is what I'm the most interested in, is moving forward with this thing, is to get her back on the, to have her reporting to Miss Atkins and getting her random drug screens if she gets called in, and doing that, and let's see where we go. I mean, it seems like she's trying to she's taken enough responsibility to get an attorney and try to handle this. So I would like to think that if she has power over this issue, she will, be trying to do the right thing. And if she doesn't, then we'll know that we need to go in that direction and see if there's some help we can give her. But you understand what I'm saying?
Yes, Judge, I do.
All right.
Judge, if I could, for a second, there is a pending warrant on her, and obviously we have our motion filed. I don't think I'd ask if she's right there by Julie. I'd like for her to walk right over there and take a test right now.
Well, conceivably that could happen. I was hoping to get Julie on to join back on the call. But yeah, there she is. She's coming in. All right. Hello, Julie.
Hello.
I let you go, and I should have asked you to stick around for this next one.
Well, I kind of got the heck out of Dodge too fast. I didn't let you know I was.
Well, no, that's not your fault. This is Miss Compton, who had two cases out of district court that you were helping supervise, and she's been indicted on both of those. You have filed a report that was filed, let's see, back about 2 weeks ago, that she had failed to show for her last drug test or two that you had called her in for. There is a warrant on her. I would be willing to recall that, but on the condition that if she can get a drug test today. So that's what we wanted you back on here for, was to make sure that that could happen. And then she's got a different address than she had when all this started and all that. So I want her to continue as a condition of me recalling that. If I do, I would want her to continue reporting to you like she'd been ordered to do previously. And to do that, she probably has to update her contact information with you.
Okay.
So I wanted to know if you were available to take care of that today, this morning.
I am. Now, Judge, you're kind of cutting in and out. I understood you say you wanted her tested today.
That's what I would like, yes.
Okay. And is she aware she needs to do that, or do I need to contact
Well, she's on here right now.
her? Okay. Okay.
Yeah. Her attorney is Mr. Brown, who's just right
Okay.
around the corner from you on the north side of the
Good deal.
public square. And so it's just a hop, skip, and a jump from where you are. And
Okay.
so I'm going to ask her to go over there and do that. In the meantime, listen, I mean, I'm not going to ask her to get back on the call. I'm going to let you tell me if we're having a problem. Other than that, I've arraigned her today. She's pled not guilty in both cases. Bruce will set a pretrial conference. I don't know what you want, a month or 6 weeks, whatever you want, so that you all can get into this. These aren't, these aren't going to be exceedingly complicated, but both of them have a DUI, and a lot of times that's the most complicated charge that you got it's possession cases. So you're going to be able to look at it and know pretty quick what's going on, I think.
Right.
All right. So why don't we do this? Why don't we, Mr. Richardson, the Commonwealth's motion to revoke bond, right now, I'm just going to technically, I'll pass it over to the day that we have the pretrial. And then I'll recall the warrants that I have if Ms. Atkins lets me know that everything's good. Okay?
That's fine, Judge.
In the meantime, Ms. Compton, I want you to walk right around the corner there and meet with Ms. Atkins, update your information, take care of business. We'll set you for a pretrial conference on April the 13th at 9 o'clock. Mr. Brown, would you like us to email these indictments over to you?
That will be fine, Judge.
Yeah, we can take care of that. All right, are there any questions?
No, Judge.
Okay. All right. Ms. Atkins, just let me know if we have a problem. You don't have to tell me if everything's fine, okay? All right, thank you.
Thank you, Judge.
See you. All right. Mr. Bell. You still with me?
Yes, sir.
Why don't we take care of our the Greene County or Taylor County?
Yes, sir. Mr. Bennett. How you, Zach?
Yep.
Getting by okay?
Yes, sir.
All right, so this is on, are we on for a pretrial conference?
We are, Judge.
I'm sorry.
No, go ahead, Johnny.
We were going to mediate this. John had sent me a request that not waste time, and if we weren't, thinking we was gonna be able to get, close to it. So, that's a hard thing to give a guarantee on. I told, John I'd come by and see him about that, and I'm still planning on doing that. So as of right now, though, he's sentenced over in, Greene, in Greene County, he's in Taylor County Jail on that sentence, and we'll try to, I just asked for another pretrial be set out, Judge, until we can either set a trial date or do a mediation or get a resolution.
Well,
Yeah.
Judge, I guess while we've got Taylor County on there, if he's going to be there for the foreseeable future, to find out whether that's going to be a possibility that we can even conduct a mediation, by Zoom for him, because otherwise, it's not going to happen.
Right. Well, there's two things that I'm thinking of in that regard, Mr. Gardner. And the first one is that if you did the mediate, I mean, hopefully, if you did it in, let's say, April or even late March, there may be a way I could have him transported to, from one. He's a state inmate, but that doesn't mean that we can't transport him for court, and a mediation would include court. So, I mean, I could have him physically brought to where we're going to be as soon as we're able to open things back up, which is looking fairly promising. First time that I've been able to say that in 6 months or whatever. But so I think we could make it work.
Okay.
And I said there were two things, but it was really just the one thing. I mean, the other thing is that we certainly could. I think they would allow him to get on a Zoom call just like this. I mean, it would be court. So if I needed to do an order and send them a link and all that, I think.
Yeah, it would be a little bit longer period of time than.
Yeah, we might have to work around their court schedule, which would make it a little more complicated to get it set. But I
We can make it happen.
Yeah, those guys they'll probably work with us pretty good.
Yes, sir.
Yeah, thank you.
And Judge, if you would set it out far enough that I'd have time to go over and talk to John about, whether we need to move forward, how we need to move forward the case.
Yeah, Johnny and I have had conversations about this. I mean, I've talked to the victim, told him sort of what our bottom line is. And there's been a couple of mediations. Johnny hadn't been involved in them where we haven't even gotten close to agreement. And I don't want to, like Johnny said, waste people's time if we're not going to have any shot at doing it.
But I will say that John and I have been able to resolve, I think I've resolved every case I've had in mediation with the exception of one in Hart County.
I can think of one in Barron County y'all didn't resolve.
Yeah, we did too. It finally resolved. You talking about the Lewis case?
No.
Oh, yeah. Yeah, I forgot about that one. Two.
Yeah, don't forget who you're talking to now.
Something like that.
No, let's how about we put this for the first Metcalfe County docket in May, and that way, if you all did decide to do it, April you'd have that whole month of April. And like I said, I think we'd be able to. I look forward to being able to do in-person things. Really, that's just going to, because it's also just going to involve 5 or 6 people. So I mean, even if things were different. Even if things were the same as they are now, everybody could go to Metcalfe County and stay apart. I mean, you wouldn't have the issues that you got with a big court docket. You know what I mean? Yeah. So, we've had the occasional in-person thing even throughout all of this because as long as you only have 2 or 4 people or whatever, everybody can stay miles apart and, it doesn't really offend anybody. All right, so that's going to put us at May the 11th.
At 9, Your Honor.
Correct. And just, don't sleep on it, okay? Y'all go ahead and try to get working on it if you're going to.
Yes, sir.
Yeah, Johnny, I'll just leave the ball in your court on this as far as, reach out to me if you want to do it.
Sure. I'll do that.
All right, thank you.
Thank you, Judge.
All right.
I'll be talking to you, bud.
Yes, sir.
All right. Thank you over there in the Taylor County Detention Center. That's got us taken care of.
Yes, sir. Thank you. Have a good day.
All right. You too. Thanks. And then Mr. Bell, you have one in Barron County?
I've got Bradley Wilson for sentencing and Nicholas Patrick is in Barron County Jail, Judge. I've also got Monroe County at 10 o'clock and they're texting me now. Do you want me to stay on and do those and do late there? Or do you want me to, I don't know what your docket looks like.
Well, that's up to you. I mean, the sentencing isn't gonna take very long if we're able to do it. But I don't know what we're doing on the jail docket.
Well, Johnny, on Bradley Wilson, are you, that appeal, I know that an opinion was given, but are you filed for a rehearing or what's?
We haven't as of now. That's something we're contemplating. I don't know what our time looks like at this time. I hadn't talked to Bradley until recently, so that's something we're looking at. Unless, you know, and some of it, you know, depends on what we do today too. You know, in some ways we want to get it over with.
Yeah.
But do we have a PSI on this already? Or was the PSI done prior to the appeal?
You know, that's a really good question, Johnny.
I
know it's a good question because I don't have an answer to it.
Right. And that was one problem that, you know, that we had this morning. You know, I was going to ask to pass that until we could get the PSI. You know, I just don't remember, Judge, if it was from the past or not. And I don't think we did.
Yeah.
I don't care to
here.
pass it.
Officer Ford, is there a way for you to look into your computer system there and see whether a pre-sentence investigation has been done on Mr. Wilson?
She completed one on October 31st, 2019.
All right. So, Johnny, what we can do is if you want to pass this 2 weeks, that'll give you the opportunity. We'll send you that PSI and then you can get it to him. Is that okay?
Yes, sir.
All right. And then, you know, you can, if we're ready to go forward, you tell us and we'll go forward on that day.
Yes, sir.
I think he's on here. I think I saw him earlier. So I know he's
here in the office, Judge. Bradley.
Oh, okay. Do what?
I was asking him to come back in case you need to see him or something, Judge.
No. I thought I saw him on here earlier, but it must have been a different Wilson. I mean, there was somebody named Wilson, I thought.
Right there he is, Judge.
Good morning, Judge.
Yeah. Hey, how you doing?
Doing well.
All right. So, yeah, Johnny, let's go 2 weeks.
Yes, sir. We'll go to the 9th at 9. Judge, I've got 1, 2, 3, 4, 5, 6, 7, 8, 9. I've got 11 home for that day. You wouldn't want to go one more week, would you, to the 16th?
Well, we won't be having court on the 16th. We can go 2 weeks. I mean, it ain't gonna make a lot of difference to me.
On the 23rd, that'd be great, Judge. I've just got one on that date.
Most of yours that you have on, I mean, I don't know how many of those we'll be able to do if they're not in custody unless you want to have them come to your office or hook up some other way.
I usually just have them come here, Judge, what I usually do, but I'll do whatever court instructs me to do.
Oh, no, listen, I'm willing to do whatever we can. It's just awful hard to do a lot of these.
I always, ever since we started this, I have everybody come in. That way it makes, you know, it's just a lot easier for me that way.
Oh, it's most definitely easier to do that from my standpoint, because then I know they're connected and all right. So we'll take Mr. Wilson and we'll move him over to March 23rd. Okay.
He's free to go, Judge.
Yeah. Do we need to send you that PSI?
If you don't mind.
All right. We'll email it to you.
Thank you.
All right.
All right. And the last thing I've got is Nicholas Patrick, but he's in the Barron County Jail, Your Honor.
All right. Nicholas Patrick.
He's present, Your Honor.
Yeah. Okay. What do we have
if it pleases the court, Your Honor, it's my understanding, Nicholas was out on bond for a long period of time. He had a dirty test, and he had a warrant out on him. We tried to get that recalled without any luck. He turned himself in, I believe, last Thursday and been incarcerated ever since. I would ask the court to let that be a sanction to Mr. Patrick and allow him to be released back out on bond. He's got a good job out here in the factory in Glasgow. I think he was just fixed to be promoted to supervisor or foreman. Is that right, Nick?
Yes, sir.
Is that job still available?
Yeah, it's at NEMAC. I've been having my fiance call in for me, and I still have a few points available. So that job is salvageable if I can get out.
That's pretty much where we're at, Your Honor.
All right.
I
Who
think
filed
it's
Mr. Gardner filed the motion, I think.
Yes, Judge, we filed a motion to revoke bond in this case. We request a hearing date on that. There's also been an offer out in this case for some time. We haven't gotten a response to that. It's a DUI case. There's going to be some, I think, mandatory jail time associated with that if there's a plea accepted as well. So we would ask for a hearing to be set on our motion.
Yeah, all right. Here's what I'm gonna do, Mr. Bell. And the main reason I'm gonna do it is because I know that he had earlier, we had a previous hearing, not a violation type of hearing, but a previous hearing about whether I could take him off of that drug testing because he had done pretty good. I think he had a slip up when it was in district court, but it had been in circuit court for a while and he hadn't had any issues. And, obviously this is something that I'm not going to be happy about and the Commonwealth isn't either. But, I also, if he's got a really good gig that he could lose, I don't want that to happen. But here's what I'm going to do. Because we just set you on the 23rd of March for Mr. Wilson, I'm going to move his pretrial and we're going to have a motion to revoke or hearing on the motion to revoke bond on the 23rd of March. I'm going to let him, if he can get I'll let him get an ankle monitor between now and then so he can get back to work and keep his job. But I mean, he's going to continue to be drug tested. And if there's any kind of drug test that comes back, that's just going to be added to the motion. You understand what I mean?
Yes, sir. You understand, Nick?
Yes, sir. When will the ankle monitor be available?
They probably got one right now. We'll call Julie when we get done and she can come up here and talk to you. Huh?
She's on here.
She's
I'm
still
still
on?
hanging with you, Judge.
Oh, well,
I keep my eye on where Julie's at.
I don't blame you. Julie, do you have monitors available at this point in time?
I do.
All right. So you reckon we can get Mr. Patrick hooked up today, probably?
Probably this afternoon. That work?
Yeah. I mean, it's assuming that the arrangements, financial arrangements are made.
It'd probably be this afternoon, yeah.
How much I need to bring up to you, Julie?
Well, it's a $25 hookup fee and it's $11 a day.
I can have that to her today.
Well, I mean, it's not just $36. It's what, 2 weeks, Julie, I think.
No, sir, I don't require
okay.
that up front, just a hookup fee.
Okay. All right.
He'll be on it for basically 4 weeks if assuming that he doesn't have a dirty drug test or anything between now and then. And I mean, we're going to have a hearing and I don't know what we're going to do about the bond when we get back, but I mean, just because you're telling me that he's a supervisor at one of the plants here. And I mean, if he's got that, I'm taking your word for it as an officer of the court, because I know you don't have any proof of it, but I don't think, I don't expect you would be making that up. And that's probably a much better gig than the average person's going to have. So I'd like to, he can keep it as long as he'll keep his nose clean.
Yes, sir.
All right, so we'll put the Commonwealth's hearing on March 23rd at 9 a.m. That'll also be a pretrial conference. And then, hopefully you all can discuss the case. It sounds like Mr. Gardner says there's an offer out. So maybe Mr. Patrick needs to get in with you and talk so y'all can respond to that offer, okay?
Yes, sir.
All right.
Yeah, there is an offer out, and like I said, it's a DUI fourth, I believe it is. So there's mandatory jail time if there's a guilty plea associated with that. So if y'all want to talk about work release or something like that, you need to figure that out as well.
Okay. Well, I had thought I'd filed a motion to suppress and a memorandum in support in this case. I know I meant to, So I will probably be filing something here fairly quickly.
Well, if you're gonna do that, try to get it done before the 23rd too, okay?
Well, Angel just told me that we've got it ready. All I gotta do is sign it, so
All right.
it should.
Honor, for bond wise, what would you like them to put on the paperwork?
Well, I mean, he's just being basically house arrested between now and 4 weeks from now. So he's not posting a bond technically.
Yeah.
Right.
Okay,
He's
so
been
the jail
arrested.
won't give him
He's been
any
arrested.
paperwork.
He's been arrested on a probable cause of a bond violation. He's going to remain
Yes,
in
sir.
custody. He's just going to be on house arrest instead of in jail custody. He's not going to post a bond because I haven't decided whether I'm going to grant a motion to revoke his bond or not.
Okay, Your Honor. I just wanted to
See
make
what I mean?
sure before I question. Thank you.
Understand? I mean, we'll send them a commitment order or something down there, or I'll have KP send them something so they know what's going on, I guess, but it's not, he's not posting a bond.
Yes, sir.
Okay.
Thank you.
All right.
Judge, I believe that's all I have today. I appreciate it, and y'all have a good day.
All right. Thank you. How you doing? Ain't none of my business. All right. Yeah. All right, Mr. Gardner, y'all got something you want to call, or do you want me to just start going down the list?
I'm fine with you going down the list.
All right. DeAndre Barlow.
Judge, Risa just got back and she's in the waiting room, she said. So if you could let her in, that's her case.
Oh, okay. I did not think I had anybody in the way. Yeah, there she is. All right. Ms. Holland, DeAndre Barlow.
Your Honor, I don't believe that there's any progress in this case. He still has that case pending grand jury. I mean, it's either, I think we could set this one for trial. We haven't reached any kind of agreement.
Understood. Well, and I don't know when we're going to be grand jurying again. And I don't know where this one will fall because it's been a minute since they've met. So I don't know where it'll be on the priority list.
Judge, we're going to attempt to do it next month. Like I said, attempt. I can't guarantee that we'll have one. And then if we do have one, this case will be given priority.
Okay. Well, I'll tell you what I'm going to do then. Let me put this pretrial to after, bless you, after that meeting will be, so that we can see whether or not that happens. That'll put us on April 13th. So we can put it on there and we'll see whether or not there's been a indictment. And then, if we need to get things set for trial or whatever we need to do, we'll take it up at that point. Okay.
Okay.
All right.
Your Honor,
Yes.
I would like to address bond in Mr. Barlow's case.
All right.
From talking to him, his mother is really ill right now. He's afraid that she is not going to make it. He tells me he has a good support team out in the world. He wants to get to work so he can start putting something back, either to help his mother when if he has to go in for jail time, or for anything else that might happen. And and from my understanding, the alleged victim in his cases no longer lives in Kentucky. He has no interest in having any contact with her whatsoever. Also, I'd like to mention that the jail is incredibly crowded. I have not been able to use the attorney-client room for like the last 2 or 3 visits I went. The jail's very, very crowded right now. I mean, he's just been sitting there for months. So, I mean, if we could do something to reinstate his bond, that would, until we can figure out what we're doing, it would be really beneficial, I think.
Miss Gardner.
The Commonwealth would oppose any kind of bond on Mr. Barlow. If you recall, the facts associated with the motion that we had to revoke bond involved a strangulation charge, an assault charge involving the same victim that we have in this case. I think that both cases show that Mr. Barlow is a danger to the community. And if he were to be let out on bond, I think that he would have to put down some substantial security, would have to have an ankle bracelet. But just to get out on bond, his past record shows that he doesn't really have the ability to control his conduct. And I think that he would be a danger to the community if he were let out.
Yeah, well, and certainly we had a hearing. I recollect the allegations in the hearing, the testimony. I mean, things were fairly serious in light of the pending charges that are already in place. To have those allegations come up are pretty disturbing, frankly. Mr. Austin, I understand where you're coming from. I don't know that I'm prepared to do that at this point in time. I may change my mind. I'll think about it. But at this point, I don't know that there's really been enough to make me feel good about it. This was a pretty serious incident that we're talking about here. Not pretty serious, very serious.
Mr. Barlow is not opposed to an ankle monitor. I'm sure he could get that done. As far as what Ms. Gardner means by substantial security, I'm not sure what she means by that, but if it's too substantial, I'm sure Mr. Barlow would not be able to afford it, considering he has me as an attorney.
But that's what I mean. I think he needs to put some money down, considering the charges that are pending. He's a persistent felony offender, and then he goes out and he assaults and strangles the same victim in this case. So I think that he would have to put a substantial amount of money down to secure his bond, considering his actions.
Well, like I said, I'll think about it, but right now at this hearing on the spot, I'm not going to make any changes. I may. Obviously I can do that whenever I feel like it's appropriate if I do come to that conclusion, but I'm not going to do it right now. Okay. All right. Thank you. Willard Flickner. He's right on top.
Your Honor, this is my case, the motion to revoke probation.
Yes, sir.
I think we're set for hearing today.
Yes, sir.
And Mr. Alexander is on the Zoom call. Call him as a witness.
Jason, are you on here?
Yes, sir, Your Honor.
All right. Can you get your camera to work, or are you not where you can do that?
Got it working. We hit turn that light on. Yes, sir.
Right, very good. Raise your right hand, please. Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
All right. Go ahead, please.
You state your name for the record.
Jason Alexander.
You work for probation and parole.
Yes, sir, I do.
And you supervise a William Flickner.
Yes, sir, I did.
And when did he begin supervision?
He began on November 24th, 2020.
And did you file a violation of supervision report dated December the 22nd, 2020?
Yes, I did.
Did it list absconding as a current violation?
Yes, sir, it did.
And could you explain the court why you filed that report?
Yes, sir. Since Mr. Flickner was probated on November 24th, he failed to make contact with me. After a month of no contact, I tried to reach out to family. I did checks with jails, hospitals, and he made his whereabouts unknown. And that's when I filed the report for absconding, because I had no contact with Mr. Flickner since being probated.
So after he was sentenced by the court, you had zero contact with Mr. Flickner?
Yes, that's correct.
You said you try to make contact with family. Were you able to reach anybody? Or
I have his daughter on my caseload, and I reached out to his ex-wife and all the family members, and they said they had no contact with him.
Okay. So you weren't able to get any leads from them to find out where he was or make any contact with him?
Yes, sir, that's correct.
No further questions.
Very good. Mr. Austin Cross?
I have no questions for Mr. Alexander.
All right. Mr. Gardner, anything further?
No, Your Honor.
All right. Mr. Austin, any proof?
As with anything, Mr. Flickner gave me some reasons, but I can't really put those on the record without him testifying. I can't really strongly recommend that he testify, but if that is what he wishes to do, he may do so.
Do you want to testify in opposition to this motion to revoke your probation or not?
No, sir.
I'm sorry?
No, sir.
All right.
I would ask the court to have some leniency on him, either, put more stringent conditions on him or give him a sanction or something of that nature, but I have no argument or anything.
All right. Mr. Gardner?
Your Honor, Mr. Flickner was granted the privilege of probation at sentencing, and after he was sentenced, showed no effort to report to probation and parole. Based upon that fact, I don't think that he's going to be able to be supervised in the community. He showed that, very quickly in this case, and did not report on a single incident after he had been sentenced. Also, based upon his, prior conduct and criminal history, he's shown that he's, a danger to the community and a risk to reoffend if left to his own devices and needs supervision. And so for those reasons, we've asked that his probation be revoked.
Well, listen, you in one sense, you kind of get a clean slate when you start over in probation, because, that's your conduct on probation is what matters, I guess, in the sense of trying to decide whether to revoke probation or not. But in this case, there is no conduct on probation because he never reported to the probation officer. And the problem that I have with that is that while the case was pending 2 different times, Mr. Flickner got out on bond and didn't report to the court and had to get arrested again. And that happened. Well, it happened 3 different times, I believe. But at the end of the day, what this, it just seems like a pattern of not being all that interested in reporting where you're supposed to go and showing up where you're supposed to. And I don't really have anything to counteract that. The proof I've got is that you got probated and you were ordered to report and you didn't report, and nobody could find you until I did a warrant. And that is not conducive to successfully being on probation and being supervised in the community. By definition, if you're ordered to report and you do not report, I mean, there has been a decision made that reporting is required in order to acknowledge the severity or seriousness of the offenses, and also as a matter of community safety. And so if you aren't reporting, then you are, like I say, by definition, that's a danger to the community. There having been a decision made that reporting is necessary for the safety and protection of the community. All right, that's what probation is. So, you know, I normally what you did before you got on probation is not all that relevant to whether or not you ought to stay on probation. But in this case, it's just kind of a continuation of a pattern of not reporting or showing up where you're supposed to. And like I say, it's been 3 or 4 times just since these cases started last year. You know, I don't have necessarily any explanation for it, but
Ain't no way around.
it doesn't make any sense. All right. Mr. Flickner, the motion to revoke probation will be granted, okay? All right, thank you. OTA.
Thank you. I'll see you at 1:30.
All right. Do we have Nisa Gossett?
She is in Park Place.
Okay, I was thinking there was something along those lines.
She is, Judge, and she is compliant. So
I want to say she said she gets out tomorrow, but I'm not positive.
Yeah, correct. I graduate tomorrow.
that's right.
Oh, are you on here?
Yeah.
Hello. So I guess, Robert, we ought to put this off to maybe a month, and so that she can get out and then come see you or meet with you or talk with you or whatever, right?
Yes, sir.
All right.
She is
Ms. Gossett?
working on placement in a halfway house in Bowling Green, Your Honor.
Yeah.
Okay. Well, you have Mr. Austin's contact information?
Yes, sir.
Number? All right. So when you at least get out of where you're going and where you're going to be next, give him a call so y'all can start discussing what's going to happen in your cases, okay?
All right. Thank you.
You bet. That'll be March 23rd, okay?
All right. Let me write it down. March 23rd at what time?
9 o'clock.
Thank you.
Yeah, thanks. John Eric Lynn.
Judge, Robert has offers in this case. He's communicated with me about, I guess, one clarification to that. I've replied and said I would run the 2 pending Metcalf cases concurrent with each other, but everything else it would run consecutive to any prior cases. So that's where the Commonwealth is. I don't know where Robert is.
I talked to Mr. Lynn yesterday evening and told him about the clarification. I'm trying to think of how to try to explain this without violating client confidentiality. He's not opposed to it, but there's other things going on apparently that I have some grasp on, but I still think I need to talk to him a little bit more and get a better grasp on it. That apparently is making him hesitant to take the offer right now.
Okay.
I would say I need a little bit more time. At least a couple of weeks, if not a month, just to figure out what get my head wrapped around it. I know the court's getting impatient, and you know, like I said, he's not completely against the offer, but you know, we're also we haven't gotten to the point where he's ready to pull a trigger.
All right. Hey, let's do March 23rd. All right.
All right.
All right. Amanda Nichols.
Excuse me, Judge.
This is Russell County Detention Center. We have Carrie Johnson. We had an invite for her. Does she have court today?
Oh, who now?
Carrie Johnson.
Carrie Johnson. I don't have that name on my docket. I'm not sure what exactly happened. Hold on, and my staff attorney's going to look her up on the CourtNet. Okay, I'm sorry.
Thank you.
I did not know you all were on here.
Yeah, we're under a different name today. Sorry.
Hey, that's not a problem. I apologize for having you on. I didn't know that. Did it get moved because? Okay. We have her down for April the 13th.
Okay, we'll see you then.
Okay, is she still going to be with you then?
Probably. More than likely.
Did she have a bunch of cases there in Russell County? Was that the deal?
Yeah, she's got a holder here, and then she's got a couple different counties also.
All right, I got you. Yeah, I kind of vaguely remember talking to her when we did her arraignment. Yeah, we got her down. We got her down right now for April the 13th. Okay.
Okay, thank you so much.
Thank you. I'm sorry about that.
You're fine. Have a good day.
How does somebody get invited and not be on the docket? I don't get that. All right, this is Miss Nichols. Miss Nichols is on here for I think we probably have an arraignment that we need to conduct. We arraigned her in Bering Circuit last week. This case is an indictment from the Metcalf Circuit, grand jury 20 CR 055, charging the offenses of possession, controlled substance, first degree, first offense, possession of drug paraphernalia, and DUI. Ms. Nichols, I'll appoint counsel for you. I appointed counsel for you over here when your case was in Barron County and, or when we discussed your Barron County case. Mr. Austin, does she do you all want me to do a formal arraignment with rights and reading of the indictment, or you want to waive that?
Waive it.
Waive it.
Okay, fair enough. Ms. Nichols will appoint counsel, put you down as a not guilty plea, right? Mr. Austin, let me point out to you one thing that you may not know because you don't have the indictment in front of you. Her co-defendant was Scott Mars, who we just did a plea on a week or two back, and you represented him.
Greg will be taking Miss Nichols because he has her in Barron County as well.
All right, fair enough. I just wanted to make sure that everybody was aware of that. I knew that you all would be aware of it at some point when you got the indictment, but all right. So we're going to put her down here for a not guilty plea. Yeah, there is a bond revocation hearing on March 23rd, right? So since Greg's going to be handling that, Robert, do you see a problem if I set this pretrial on March 23rd and put it in Barron County?
No problem.
All right. And then that'll enable us to keep all these things in the same conversation, at least for now. Okay. So counsel appointed, plea of not guilty, pretrial 23 March 2021, 1:30 PM, Barron County. Okay.
Yep.
Thank you. Timothy Pittman.
Yeah, Judge, he was released last time. We were in court. He was supposed to contact Robert. I don't know if that's been done or not.
I don't, I'm not sure if he did or not. I'm not seeing it in my notes, but I'm not always the best at note keeping. Let me see if I got it marked on these computer notes.
I was just checking on my memory of this because I distinctly remember when I let him out to tell him to contact Mr. Austin and get the Zoom link from him and get on this Zoom hearing. And since he is not on here, and since
Yeah, I don't believe he ever called me.
yeah. Well, I mean, whether he did or didn't, he was supposed to get this link and he was supposed to be on here. The Commonwealth made an offer, and it seemed to be an offer that you all were going to go along with. That was part of the conversation. He had said that he didn't know he was supposed to still go to Julie, so I told him that he had to still go to U-Turn. I don't know whether he's come up for any tests in the last 2 weeks, but you know, I told him in no uncertain terms to be on this Zoom link. I thought I did, but I had to check Crystal's notes to be sure, and she said that that's in her notes. So,
Your Honor, my notes reflect as well that he was informed that it's going to be on Zoom and that he needed to contact his attorney and be present.
golly gee. Well, according to the Kentucky Supreme Court, an order to appear remotely is the same thing as an order to appear in person, standing right up here like you normally do, and therefore this is a failure to appear. So we will issue a bench.
If you don't have the right name on your picture, right?
I'm sorry?
I'm here. Excuse me, but my name's wrong on here. I just want to know you, make sure you knew I was here, man.
How on earth would I not know that was you? When we started, you were walking around without your shirt on. Which is also,
Muted.
I'm embarrassed to say I've seen you do before. So I knew it was you. I'm trying to get the jail taken care of so I can let those poor people go. All right.
At least I'm here. At least I'm here as a plus, ain't it?
At least you're here. I got you.
Good.
All right.
I was getting a little nervous.
No, I got you. That's the comedy stylings of Jonathan Greer, everybody.
Yeah. You put me and Greer in a room. Do we talk? I'm not sure me and Greer talked, to be honest with you.
Well, I didn't know he had a bond, and I didn't know whether he would make his bond or not, which is why I set this for 2 weeks away, but apparently he did make it. So if we need to continue that for you all to talk, I will. But now, obviously it means two things. Number one, I expect there to be a conversation between y'all before we come back. And number two, now that I know he knows how to get on Zoom hearing, I'll expect him to get on. So you all think about what you're doing while I finish writing this Timothy Pittman order. Yes.
Mr. Greer, if I give you my office number, will you call us and make an appointment to go over your case?
Yeah, I can talk to you, but I'm pretty sure I want to try to seek other counsel, man.
Well, just do something. I mean,
Little work.
I can make an appointment right now, Robert, just in case. Go ahead and get it taken care of. And then if he does seek counsel, we can take care of that later.
That'll be fine.
Mr. Greer, we have an opening for next Wednesday, the 3rd, if you would like to call our office at 9 a.m.
That'll work.
Okay, I'll put you down. Is there a phone number I can put down for you?
Yes. 678-1410.
Okay, you'll just give us a call. Even if you do decide to hire counsel, just let us know if you don't mind.
Yeah, I'm pretty sure I will, but what was that number again?
Our number is 833-385-6055.
Thank you.
Judge, I was gonna ask if you could add it as a bond condition that he meet with counsel, but at the same time, if he's not going to go with Robert, that he needs to have his lawyer issues resolved by the time he comes back, because this case, I'm looking at it now, dates back to October 2019. That's just the indictment.
Oh, yeah. Yeah. No, this is what we're doing. It's fine with me. However you decide to go counsel wise, Jonathan, is fine with me. All right. But, I'm going to put this off for 4 weeks, and I want you to do one or either contact Robert and y'all talk about your case and get back on here. Or if you're going to hire an attorney, do that and have your attorney get in touch with the DPA and the Commonwealth real quick so that they know that there's somebody else working on the case. Okay.
Right. Well, I'm a little bit, I'm starting my own business and I'm trying not to spend too much money on it. I believe we'll have a resolution to it pretty easy. And I'm just trying to get figured out what I want to do. And I don't believe it'll be a big deal. But I can't afford Mr. Bail these days.
What, just like I say, just make a move in one direction or the other. Okay.
I was thinking maybe I could get with the Commonwealth attorney and get it resolved just like that. But I don't know. Best to have a lawyer anytime, ain't it?
Do what?
You better have a lawyer anytime you do anything. I think I could probably get with the Commonwealth attorney and have it resolved. Let you split, but I'm going to get a lawyer. I'm not really impressed with the public defender, to tell you the truth.
Well,
I can't afford Mr. Bail these days.
All right. Well, listen, I don't care what you do, but do something. Okay.
Gotcha.
All right.
Thank you.
That's it. Thank you. March 23rd, 9 o'clock.
See y'all.
Let's see, Mr. Posey.
Judge, last time we were here, I've had an offer out for a while in this case, and Mr. Austin said he needed to meet with Mr. Posey, so I don't know where we stand at this point.
Mr. Posey was not inclined towards the offer when I talked to him, unless his mind's changed, but I don't think it has. I think he may still be considering trying to get outside counsel, but not sure if we addressed whether he was doing that or not last time. But when I talked to him, he was still not really interested in the offer. Mr. Posey, would you like us to go ahead and set it for a trial date?
I don't know. Give me a couple of weeks and come back and talk to him. I'll decide then.
All right. Guess you can put it on in a couple of weeks and we'll find out whether he wants to put it to trial or not.
March the 9th at 9 o'clock. All right.
All right.
Thank you. Bonnie, how we looking?
That's all I've got, Judge.
I shall see you later, okay?
See you this afternoon.
This afternoon. Thank you.
Please do.
Anybody else have anything they can think of?
Judge, I hung in here to report that Miss Compton has either taken the scenic route or she's not coming. So she still hasn't reported.
Well, I think she's probably had enough time since it was a tree sloth could get from Robert's
Right.
office by now.
Right.
Well, so here's what I got to do. Somehow we only issued the warrant in the one case. And so I need Laura to issue the other warrant in the other case. And we need to tell them what her address is because it's different now. She lives down Fountain Run. And I mean, I gave her the chance. I don't know what else to do.